from Lawyers for Human Rights in South Africa, and I speak on behalf of the Institute for Policy Studies, or Transnational Institute. We take the floor to express our strong support for the proposal by the delegations of Palestine and South Africa to Article 6.4c during the 10th session, which de facto introduces the right to say no as an essential component to meaningful consultation. This proposal rightly affirms that affected communities have control over their territories and their ways of living. It is imperative that this provision not be reduced to a procedural formality or a mere tick box exercise. Rather, it must embody a genuine and robust process of obtaining free, prior and informed consent from all potentially affected communities and people. Without a clear objective, meaningful consultation risks becoming an empty exercise. We therefore recommend replacing affected groups and other relevant stakeholders with affected communities and peoples to avoid the unintended inclusion of entities whose interests are commercial rather than grounded in human rights or territorial integrity. As highlighted by Palestine and South Africa, free, prior and informed consent is not a procedural courtesy, it is a right. This right must include the explicit recognition of both the right to say yes and the right to say no to operations and activities of transnational corporations on communities' lands, territories and waters. Such consent must be regarded as binding, regardless of whether it aligns with corporate interests. This is critical to safeguarding communities from coercion, manipulation and fear of reprisals. FPIC should be understood to include the right to receive timely, accessible and culturally appropriate information about the risks of proposed business activities before it begins, the right to freely express concerns or opposition without pressure, coercion or retaliation, and the right to say no. That is, the right to withhold or withdraw consent and have such refusal result in the prevention or cessation of business operations. We further emphasize that the responsibility for ensuring effective consultation rests exclusively with the state. We therefore support the proposed language of Article 6.4c as suggested by Palestine and South Africa, which ensures that consultations are conducted throughout all phases of operations, follow the principles of FPIC, are carried out by independent public bodies, pay special attention to communities facing heightened risk, such as women, children, persons with disabilities, indigenous peoples, people of African descent, older persons, migrants, refugees, internally displaced, and populations in conflict or under occupation. And that where meaningful consultation is not possible, such as in conflict zones, business operations must not proceed unless clearly in the interest of the oppressed population. Finally, we call on states to converge on these proposals and formally support them in this formal space of the negotiation. Thank you.